slowly filling up.
Well, it's just turned 11 o'clock, everybody, so we've got a fair amount of participation already. So I'll get started and wish you a very good morning and welcome to this discussion on family investment companies, co-hosted by Roythornes Solicitors and Artorius Wealth. I'm Steve Brandreth, I'm client partner at Artorius, and I'm joined here today by three highly experienced advisors. Firstly, I have Ben Taylor of Roythornes. Ben's been with Roythornes for 10 years. He specialises in estate planning and business succession, and as you'll soon gather, has extensive knowledge and experience of both corporate and personal tax law. We then have Lizzie Walters, also of Roythornes, and Lizzie has also just passed her 10th anniversary, according to LinkedIn, with the firm. Alongside being a notary public, Lizzie is a partner in the corporate and commercial team, and she specialises particularly in the complex field of corporate restructures. Last but by no means least is Jane Folk. Jane is Head of Wealth Planning at Artorius. She is a chartered financial planner, and she has extensive experience in dealing with UK resident, domiciled and non-domiciled clients, and works alongside the role that I have as a wealth manager in terms of providing clients with investment and planning strategies. The format of the session today is discussion-based. When we put our heads together on this, we felt there was a lot of information that's been written, particularly lately, in terms of family investment companies over recent times, and there's no shortage of technical information that's out there. So probably discussing our practical involvement and experiences with these structures with some examples here and there, hopefully will be a little more meaningful and hopefully will be complementary to what you are already aware of. We're scheduled to finish 12:30, and hopefully this will allow us ample time for Q&A session towards the end. If you would therefore like to use the chat facility and you're more competent than me on these things, then I will endeavour to put those questions to the appropriate person on your behalf. Needless to say, if we do run out of time, we'll get back to you as soon as we can with an answer. So enough of the preamble and the introductions, let's get started. And perhaps I can begin with posing the question to the panel of how you'd best describe wealth planning in the context of family investment companies. Jane, welcome to you.
Morning, good morning all. At Artorius, we lead with planning. It's where we start our client conversation. And we do that because we firmly believe that we can't understand and manage a client's financial affairs appropriately unless we really understand what it is they're trying to achieve. And without sounding a bit sort of wishy-washy, it is genuinely the hopes and dreams territory. It's really finding out what's important to those clients and why, as much as anything. We often experience clients come to us at a particular juncture in their life. There's some event or there's something pressing that has driven them to feel they need either further advice or different advice or starting from scratch. And we'll always address those matters, obviously, alongside the client's focus. But my analogy is that really wealth planning is like the Olympic rings. Everything interrelates. So to give you an example, it's very common for people to come and want to talk about, well, I say want to talk about pensions, need to talk about pensions. I don't know that anybody ever wants to talk about pensions apart from me, but, you know, it is there and it's quite often people's Achilles heel. Whereas we say to them, we will focus on that and that will be where we spend our energy, but it's really vital that we understand where that fits for a client in their wealth, their focus, what their plans are for it. And to talk colloquially, and I'm unfortunately infamous at Artorius for my jam jars, but I do talk about tax efficient jam jars. It's that simple. And we firmly believe that there are quite a significant number of very standard, straightforward, tax efficient jam jars that clients can use, and that their optimal position is really achieved by using a variety of those, of which a family investment company is quite often part of the conversation. And really, it's just in the combination of those different efficiencies that you get from each of the different wrappers, if you want to call it that clients are best served, because no one wrapper has the sort of answer to everything. But it's only by really getting under the bonnet of what clients are, what is important to them, can we know how things should be sort of structured.
I completely agree with Jane on that. When we talk about estate planning with our clients, it's predominantly about looking at what they want to achieve and what their goals are, and those goals don't always present one particular solution, or some solutions won't achieve those things. And of course, if the assets don't match the structure in terms of how we're going to contribute them to a trust or to a family investment company, then we do need more than one solution. Wealth planning means different things to different clients, and for some it might be about doing a bit of inheritance tax planning. For some it might be saving as much inheritance tax as possible. Some might want to retain an income, some might not be interested in that, some might have different views on control, and each of those different aspects points to a different tool as part of the estate planning process, and as Jane says, a different jam jar. Often there's a mix of solutions, and a FIC will form part of that.
And I think where it's particularly useful is that control element that you're talking about. It's those people who desperately want to keep some level of control. They're not quite ready to hand it all over to the next generation yet, but it makes sense to try and start passing that wealth down. Is we've seen, the FICs be quite useful in that respect.
Sure. I think, and from my point of view, I think we've passed the time where specifically on FICs being perceived as the solution to every problem. I think there was an issue a few years ago where I would go into meetings with clients who would raise, the opportunity that presented itself with FICs. And I think their main emphasis at that time was that attraction or seeming attraction between the lower corporate tax rates compared with personal income tax. And of course, I can see why that would be. But I think things have moved on quite significantly now within the advice market. And I think it's less seen as that type of vogue thing to have. And it's more mainstream planning. So that can only be a good thing. Okay, so if we lead on from that in terms of something more specific reasons, why do you think there are more specific reasons that FICs are used, and probably what type of client might be interested? Jane?
Well, there's a vast array of people who are interested, but I would say, just in my experience, the clients who have sort of naturally gravitated towards setting up a family investment company are often individuals who've come out of business. They perhaps run their own business and they're having a liquidity event, perhaps a sale. And what's very comfortable about that for them is that they absolutely understand the corporate structure. And quite often, quite genuinely, somebody might know how to make fences and sheds and all those good things, but actually to suddenly be presented with quite a lot of cash, where they may never have done very much in the actual management of an underlying investment portfolio, it's what everybody dreams of until it actually happens. And actually that's quite a daunting experience and quite uncomfortable, because most sort of entrepreneurs are used to running the show and sort of being in charge of everything. And just at the point at which, in theory, all their hard work has come to fruition with this big capital sum, they've then got to go and trust some other individuals to manage that money. And so very often we do find that those particular individuals, if we are, and it's appropriate, and as both Ben and Lizzie say, there's lots of reasons why you would, and there's sometimes reasons why it's not the only optimal structure. But if a family investment company fits for them, then at least there's something about that structure that's completely familiar and comfortable. A bit like Lizzie said as well, I see it a lot with clients that are wanting, they have substantial funds, funds that would be perhaps less easy to pass into trust in any sort of meaningful way. And they want to give it away, but they also want to keep control. And sometimes that can be a difficult juggle. So, often the family investment company has been a vehicle, one of the vehicles for that. And probably one of the other things I've witnessed several times this year, in fact, is clients using the setting up of a family investment company, or in fact a trustee investment company, which is the same sort of wrapper, to trigger a tax event. So there was the sort of shareholding that they wanted to retain or needed to retain, but they actually wanted to trigger the disposal as such, but whilst still able to retain it. And perhaps I'll come back to that a bit in later opportunities, but they're certainly the ones I've seen most frequently.
Yeah, I think it is. It's absolutely about those people who understand companies, which, to be fair, is most people who've got some money nowadays. They've got familiar with that business structure, and have got this cash, whether it's from a sale or whether it's from profits or or inheritance, wherever that cash has come from. But there's some cash or some investment value somewhere that's surplus to their trading requirements that they need to do something with. And I think, we'll talk about the structure of the fix and how they're set up in terms of, how that works. But as I keep we've said this before, but the control element is the key, really. We can have in a FIC, unlike a trust, you can have one person absolutely in control of that company, deciding what investments are made, deciding what happens and what's happening with their money, but getting them some favourable tax treatment, which I defer to people who know more about tax than I do to comment on that. But it is really that sort of benefit of the control without control and giving it away at the same time.
Yeah, I agree with both, obviously, as Jane and Lizzie. In respect of the profile that people who go for FICs, the people who are obviously listening to us today will be talking to about family investment companies. There are a host of reasons for why someone might find it attractive, and I know that when we've spoken to investment managers before, for example, they're particularly concerned about asset protection. So building up a portfolio of investments, for example, and having them broken down by something like divorce. And family investment companies do offer protection. And I know that some of my clients who have been bitten by divorce in the past are worried about it too. But FICs do offer some protection for the underlying investment, which is obviously of benefit, as the courts tend to be unwilling to go behind the corporate veil, and the case of Petrodel is usually referenced in that. Of course, being at Roythornes, we have the benefit of a matrimonial team. So if we have clients with concerns about divorce and how we can best protect them and their assets, their investments, we can refer to them, and that might also look at prenups, for example, and postnups, taking into account the investment being made into the family investment company. I think, Lizzie, you plan to talk about structuring, as you said earlier, and how that might feature in a divorce scenario. Yeah,
that's right. And I think the main thing is that with a company, with an investment company or any kind of company, what we see from a divorce perspective is it's the shares in that company that are sort of up for grabs on a divorce, not the underlying assets. So if we compare that to our sort of farming clients who might traditionally have traded through partnerships, if you've got land that's in personal ownership, you can quite easily kill a trading business on a divorce by having to transfer those assets out. Whereas with company structures, it is much more difficult to get the assets out of that company on divorce, and that can be important from an investment perspective as well. And you talked to Jane about sort of having sort of this one vehicle for stuff that can't be split up. Is it works on divorces and inheritance as well, is trying to keep everything together whilst splitting the value as thinly as you need to.
And we've seen that also just when there isn't divorce, but just when, as it comes down the sort of generations, the number of people joining in and taking a share gets bigger and bigger, and that can become really cumbersome if there's direct ownership of, for example, a property portfolio or something like that. So very often it's much easier to sort of separate things out through shares in a company. And as you say, the underlying investments, land, whatever it may be, is held intact without it being quite so messy.
I think from my point of view, it tends to be when clients start to become more focused on IHT planning, but probably more committed to do something about IHT planning. As they get older, they become more certain, it appears, about their own financial requirements. There's less uncertainty about probably the sales proceeds of a business in terms of what it can and would provide for them personally. And they feel more able to commit to making inheritance tax plans and effectively giving away. And you've talked about the control, which is clearly important, because their children are probably getting older as well, but the parents are probably still less inclined to relinquish control altogether, either because the child has not yet settled into a relationship or a marriage. But equally, I found that they probably lack the amount of financial maturity or financial responsibility that the parent thinks they need to take on such a large amount of money.
Yeah, I agree with Steve that the inheritance tax factors do definitely play a part. And as we've already said, in terms of who's looking at creating a FIC, people with cash. There's been an event, let's say the sale of a business, for example, and very often we refer to cash. It's usually the easiest asset to deal with when it comes to a FIC. But that asset, that business interest, was perhaps relievable, and now they've got a big pot of cash not relievable. And I know that we're going to discuss the structure, but the IHT benefits that come from that tend to come from either holding shares that don't grow in value, which means all the growth in the value of the FIC is outside of your estate, or relying on a decent minority shareholder discount. The sums involved may mean that a settlement isn't possible, for example, as I said before, in terms of the wealth planning motives. It might be that they want to get an amount outside of their estate, perhaps in cash, that means the trust is sort of ruled out, or at least can't deal with all of it, without incurring lifetime IHT. As we've said before, and I think Jane will agree, trust will still usually play a part.
Yeah, very much so. Yeah.
Okay, so thanks for that. I guess we're given a broad sort of perspective in terms of sort of FICs, as an entity. But moving on to the actual structure of the company, I've seen many different variations using trusts, for example. And it's probably a question that's more aligned to the lawyers on this call. But what is your thought process in terms of structuring the company?
I think I'm going to give that really annoying lawyer answer of it depends. And the fact is, we basically have a complete blank piece of paper when setting these up to do whatever it is the client wants to do, or to achieve whatever it is the client wants to achieve, perhaps rather. So when we start those discussions, there's sort of four things that we would be talking about, or four headlines that we'd be talking about. So the first would be decision making. So who's going to make the decisions at shareholder level, and who's going to make the decisions at director level. So I think everyone who's listening to us today is probably sort of familiar with company structure. So, but the directors obviously are running the business, and the shareholders own the business, and they may or may not be the same people. So often we see the older generation, the people who are setting up the company, wanting to be the directors because they want to have that day-to-day control over what's happening, what investments are being made, and all of that. So we then would talk about, as I say, voting rights at shareholder level. When is it appropriate for the other shareholders to have votes? Do they ever have a vote? Are there sort of key decisions that we want to say, well, actually, we'll run this company, but if we want to do X, Y, and Z, we'll talk to you about that. And we can use the articles and the share rights and the shareholders agreements to achieve what they want to there. The next sort of headline is income rights. So these are the dividend rights, which, depending on how the FIC is funded, it may be a little while before any profit is actually distributed to the shareholders. But, do we want this to be something that generates income in the short term? Is it something that is designed to get income to individuals or perhaps to trusts that own shares in the FIC? To pay school fees or whatever it may be, or is this more of a long-term thing that no one's designed to get any income out of for a little while, and we can split those income rights as we need to. The third is rights to capital. So who owns it and what are those shares worth? So when we're looking at that, as Ben says, we might have growth shares in there, so a class of share that is only ever worth £1 a share, and then all the growth goes to all the other shareholders, or we can have a bit of a mix there. And then also ownership. So this is where we'd look at restrictions on the transfers of shares, preemption rights, any permitted transfers that can be made. So and who is allowed to own this company. And that's really, again, it's where the control can be kept, because it's within the power of the people who are setting this up to make sure that this is set up right from the off, that they've thought about where they ultimately want this company to end up. And, we can include compulsory transfers if people die or get divorced. And, we've got complete flexibility with that. What I might just do is, what I've got is a few examples of some FICs that we've set up recently in terms of what the rights are, which might just help to illustrate the various different options that we've got. So if you can see that, so nod, yeah. So in this first structure, we had a company, we had Dad who had come into some money from the sale of some investments in his personal name, and he wanted to do something with that cash for his 2 children, and also he had minor, very young grandchildren. So what we did in that case was we set up the company with 5 classes of shares to enable us to have 2 trusts, one for each of his children's children and remoter issue. They each had a class of share, as you can see. So there's Dad, son and daughter, and then the 2 grandchildren's and remoter issue trusts. Dad wanted to retain all of the control of that company, so he had all of the voting rights and was the sole director. So he was able to, whilst he has all of the voting rights, he's able to have full control over who is appointed to the board, who's making those decisions, and is running it. But he didn't want any capital value. The money that he put into the company, and we will talk a little bit about funding, but the money that he put into the company was done by loan account. So he had that as his income effectively for the next probably 20 years. So he didn't need any capital value. He was happy to hand over all growth to the others. But we kept him having some dividend rights just in case we needed to get some income to him. The other 4 sort of categories of shareholders then had a different class of shares, simply so that we could flex the dividends if we needed to between the 4 of them, but otherwise they would share all that capital equally between the four of them. This second structure was a slightly more simple structure in that, again, we had one individual who wanted to retain control, but wasn't to have any capital. But then we also had his wife who he wanted to put into the company so that if there were any dividends, if there was the opportunity to do that, we could flex the income rights a bit and get her some dividends. Other than that, she didn't have any rights. And then he decided that he was going to treat the 5 children exactly the same. So the 5 children had exactly the same class of shares, so that if any dividend was declared, they'd all get an equal amount. They'd all share in the capital equally, and they effectively would run the company later on. What was really interesting about this particular one is because there were 5 children, we had to think quite carefully about where his voting rights would end up when he died, because it was a question of, do we then split those between the 5 children? Which then means you've got 5 children with equal voting rights, and if they can't agree on something, we end up with a company in deadlock. Or are those voting rights left to a trust under his will, so that effectively an executor can come in and operate the company even though the children owned it? And in his case, he decided that that was better. Rather than having the 5 children inheriting the voting rights in the first instance, they would go to his trustees, as the rest of the estate might. And then the third and final example that I've got is just to show what we can do differently with capital values. So in this scenario, the mum and dad wanted to make sure that they did have some capital, but it was a very limited amount of it. So effectively, the first £100 a share was given proportionately across the piece, and then any growth was split between them or between the children. And obviously that £100 figure could be £1,000, 10,000, whatever that number is, but it was a way of them quantifying exactly what their IHT bill was potentially going to be, because they always had a fixed amount or maximum amount of capital in this company, and then passing the rest on to the children. So that's just a few examples, but as I say, it's a blank piece of paper really.
I think the only thing I'd add to that, when it comes to setting them up, and obviously usually responsible for things like tax, is looking at settlements legislation, which, I mean, it always comes up when looking at share structure and gifts and where the money is coming from, and it's usually likely to be more of an issue with family investment companies, simply because it's more likely than in an arm's length deal that you're going to have gifts and the possibility of a shifting of income or capital, and getting other generations involved, so grandparents involved, to make settlements for children. And when I say settlements, it's really widely defined. It's not just the traditional sort of discretionary trust, that sort of thing. So if you're advising on a family investment company and you're involved in the structure of that family investment company, being familiar with the settlements legislation and I guess to a certain extent how HMRC interpret that and have a look at their manual, it is imperative.
Probably all I would add to that really is just a couple of examples that I've had again in recent months. One is where there was already a trust set up and a family investment company was inserted into it. And that was actually a very significant life interest trust. And the corporate, the family investment company, has been put into the trust in order to control the flow of dividends, because as we know, in a life interest trust, the life tenant is responsible for the taxation that arises on the income, regardless of need. And because of the quantum involved in this, it was going to be far more arising than was necessary in terms of meeting need. So it was thought that inserting a company in that actually acts like a valve to be able to control the flow of dividends. So the investments could operate within the family investment company, but there was no obligation on at what point the dividends were paid out from the corporate, which has just worked really well. And probably the other one, which I think is sort of similar to what Lizzie's alluded to already, is where there was going to be significant family value in the family investment company, but at the point at which the trust had shares in it, so that this was again a situation where the trust took shares in the corporate, there wasn't that much value. So it wasn't breaching any requirements in terms of what was in there. But of course, it then meant that all the growth in the value of those shares was held within the trust, which was much more comfortable to in this instance, the parents, who, again, there's significant wealth, but actually they're very concerned about the children finding their own way in the world and, not being taken away their sort of drive and all of those good things. But yet, they could see this was becoming difficult to call it a problem, but it can be a problem, the growing IHT burden, and at what point do you pass it across? And for them, this was a really great way actually of starting their journey towards inheritance tax planning, still being able to do what they do best, which is sort of growing their money, but actually where part of it's already moving outside of their estate, but not into the direct control or even knowledge of the children, which for them was much more comfortable.
That's a really good insight. Thank you to the three of you. In terms of sort of, we've established the structure of the company, we come on to sort of obviously funding it now, and there are clearly multiple methods of, getting assets into the company. Lizzie, what are your experience and as far as this is concerned, what are the key points that you think should be considered?
Yeah, so the simplest route is always going to be to put cash into the company, because it's readily available, it's easily transferable, and there it sits in the company. So we can then do that by subscribing for the shares, using that as the price that you've paid for the shares, or by inserting it as a loan. Most often we see it going in as a loan, because it gives flexibility to get it back. But obviously that doesn't then get rid of it from an IHT point of view in that person's estate. So there would need to be a conversation in terms of the wider tax planning and why they're actually doing this, but whether it makes sense to just keep a bit of it back for a rainy day, if you like, but allow the growth really to go on to the next generation. And that's what we're seeing most commonly, because it's that sort of starting step really. That's not to say we can't put assets in it. So I've done some recently where we've put listed shares into family investment company. Seller wanted to get rid of them because he wanted to crystallize a CGT event at the current rates. It suited him to put them into a family investment company and to have the growth passing down the generations, but keep hold of what they were currently worth for himself. So in effect, the FIC bought the shares off him and left it outstanding on loan account, on director's loan account. There's obviously tax considerations with doing that. There's tax considerations of, it is possible to just gift stuff into the company. But then again, there's IHT consequences of doing that. So again, I'm back to the really annoying lawyer answer of it depends. But ultimately, if someone's got some cash or someone's got some assets that they want to use to set up this company, they can certainly get into that company, and you can keep some of that value back for yourself. You just might need to speak to a tax advisor about doing it.
Which is sometimes where I come in. So yeah, loans are really common. As Lizzie said, they need to be considered carefully because usually it's part of a consideration of where the client's going to get their income from, because the loan is just left unpaid. They're not really improving their inheritance tax position a huge amount. But if, as I had a client recently who's basically living off capital, if that loan is going to be used and slowly going to be paid for, drawn down on for holidays and home renovation, etc., that particular client did mention a lot of holidays, then that's great, because that loan is going to disappear. Otherwise, it remains part of their estate for inheritance tax purposes. Of course, it can be, as I've said, spent, and it can be gifted, though a gift would be a potentially exempt transfer for IHT, assuming it's not to their spouse or civil partner, which means that they're going to have to sell out by 7 years. Depending on the amount, we might discuss things like insurance. Obviously, it's for 7 years, so it's not as bad, generally speaking, to get that insurance, but it's still going to be there. Interest-free loans often come up, and they aren't necessarily always an issue, but caution should be exercised around those, because certain conditions can cause an interest-free loan to be worth less than it's actually worth, such as it not being payable for a fixed period, which means that rather than being simply a loan, it might actually be a transfer of value. So because it's a family investment company and not an individual, that would be a lifetime chargeable transfer for IHT, which brings back the problem of lifetime IHT. So whilst loans are the most common, they do need to be looked at and not sort of just done willy-nilly. As Lizzie said, we do often see transfer of assets, and often that comes up with incorporation. And one of my particular specialisms is SDLT, and what I usually get is conversations about property investment partnerships, portfolios, and that way being incorporated and turned into fixed to effectively deal with income tax issues in terms of holding the portfolio, but also part of inheritance tax as well. Transferring land to a company will likely involve capital gains tax because it's a disposal, and SDLT, as I've said, because it's a land transaction. In respect of the partnership question, can talk about that later if anyone does actually want me to, but there is a different regime for SDLT and partnerships, and there are rules to prevent to cause a charge for SDLT if that transfer from an individual to a partnership to a company happens within a certain period of time. You also have to be aware of things like the anti-avoidance legislation and the avoidance legislation isn't actually avoidance legislation, the Section 75A. Selling assets might be an option. Again, capital gains tax will come into play there, and as Lizzie and Jane said earlier, that might be something that's wanted. Reliefs might be available to help with that, such as business asset disposal relief, which used to be called entrepreneurs relief, and rollover relief. But if they're trading assets, trust might come back into play. And as I said at the start, if the asset, it might be the case that the assets do kind of steer where we go with the planning. So if they are trading assets that attract 100% relief, we might then end up looking back at trusts for those assets. But fixed do have an advantage over trusts in the sense that they can be funded with non-relievable assets above the nil rate band and not incur that lifetime IHT. So again, it's really looking at, and when it comes to inheritance tax planning, I don't like doing it in a vacuum. So I like to know about the assets. Jane's nodding, that's great. I like to know what else they've got, because if we are focusing, if the client wants to focus on a particular set of assets, it might be the case that when we broaden the keyhole, it actually that there are other assets that might be better targeted.
I'll just jump in there as well, Ben. It's exactly what we discussed when we started. It's about what's the problem that needs fixing rather than what's the product, So rather than trying to fit everything into one particular jam jar or not, it's very much led by, what the client's achieving. And very much as you described, it's that getting the wider picture. And then, it's very possible a family investment company would be part of it or not. And just coming back on the loans, my experience with clients often is that when they do lend money into a family investment company, particularly when it's about passing on assets to the next gen, something around that is just a little bit about a time frame and a comfort zone. So I find very often within probably about 18 months, they feel ready to start sort of giving away some of the capital, but it's that sort of slight panic mode of it doesn't matter how many cash flow models we run for them, but will I need it? Will I need it? So it's always like, okay, it's in the structure. They've kind of got used to seeing how it runs. They've perhaps had some dividend payments back, perhaps some loan repayments. And actually everybody starts to breathe and relax. It's like, okay, yeah, no, I get it now. And then we can, and you're right, Ben, it is a series of pets, but, assuming that, all things being equal and health is as it is, we're often covered with the 7-year decreasing term life cover. It can be a very efficient way of gently and appropriately passing on value. Probably the other one that I've seen is this life interest trust, where we have set up the corporate within it, and we've loaned the capital into that. And that's been done on the basis that there are very wide powers of capital distribution from the trust. So it means that the loan in means that actual capital can be passed out of the corporate to perhaps the life tenant or another if needed, without having to trigger it as a dividend or anything else. The other thing about setting up a corporate for that particular case is that there was another trustee who is a lay trustee who is doing extraordinary amount of work for this. It's predominantly a philanthropic focus, I would say. But there was no power within the setup to be paying, even though that had been the settler's original intention, that this other trustee would be sort of remunerated. Because we've now have the corporate, we can actually pay a salary as part of the corporate as a director, which has allowed us to sort of achieve what was intended, even though actually the way it was originally set up, it wasn't as such. And on the sort of lines of what Lizzie was saying about sort of triggering gains, actually the client I've got has needed to retain a shareholding because of his position in the company, but actually it was trading at a loss. And he knows that a gain is coming down the track quite soon. So by utilising the retention of the shares, but obviously the disposal that occurs when it goes into the FIC, he has triggered a loss for himself in the right order, so that he's been able to create the loss in advance of the future gain, which means there will be an offset, which for him was quite comfortable, according to his accountant, apparently. So.
Good subnote.
Yes, absolutely. Always refer. I mean, this isn't just because of everyone on this call or Lizzie and Ben, but as a genuine, whatever we see clients having been advised on elsewhere, whilst we might say, to our clients, we've seen this work for others, our modus operandi is that it is the professionals in the room that are advising on this. It's for us just to facilitate the conversation, really, where clients might not have had that experience before, and it's just helpful in that respect.
Sure. Okay, so we've got the structure set up, and we've got it funded. So we're well on track now to actually sort of start managing the investment. So what are the thought processes here? And they probably sort of fall more into my court, being a wealth manager. So what are the thoughts there? And I guess my starting point is most definitely to go back to what you've all been talking about, Lizzie, initially, in terms of the objective of the company. So the blank piece of paper means that, the objective could frankly be like very much anything and anything in between. So, finding out what that objective is and sort of really getting underneath the skin of it, for me as a wealth manager or an investment advisor, has to be the priority. And of course, the formation of the company in the vast majority of cases, of course, indicates a long-term structure, almost certainly multi-generational in the extent of sort of passing wealth down the line. So as a almost like a default position as far as that's concerned, it would lead, any advisor, and hopefully people agree in the room, that it would be higher risk and liquidity is less than important, because you're talking possibly decades in advance before wealth is passed on. So it can afford to take an appropriate level of risk without much consideration to liquidity. But the flip side of that is, what if there is a liquidity requirement? You know, what if there is some sort of factor in there in terms of a dividend payment, or probably what's more pertinent is a loan repayment. So yes, the objective is crucially important, and what assets you've got within the company will, you know, play a huge factor as far as that's concerned. So yes, we've seen property. It's obviously great when you see sort of a lot of cash going in, because you've got all options open at that point. But when you get alternatives in there, and we've seen, you know, considerations with regards to art and cars and things that are quite esoteric, what it can sort of, in my experience, bring about is almost like a barbell asset position. So you've got cash on one side, which is obviously highly liquid, but, you know, not doing much for anybody in terms of longer term, you know, return. And on the other side of the barbell, something that's highly illiquid, but probably has some sort of some real asset characteristics: property, private company shares, private equity. So, as I say, sort of cash funded, sort of very, very much easier to develop strategies as far as that's concerned. Less so with the other thing, but, you know, of course, there is the capability of creating some debt within the company. The directors normally got the capability of sort of using the assets within the firm sort of to act as some degree of leverage possibility, but gives complications. So as a wealth manager, really, we speak, and advisors, you know, dialing in on this call will understand that we speak regularly about management of risk management generally, and focus primarily, I guess, in terms of personal investments on volatility, but then we'll look at other types of risk: inflation, capital, currency, counterparty. But still, despite all of those risks, I still think that liquidity risk is one that I speak about most with clients, and trying to sort of factor in a little bit like trusts. You know, the long-term intention is probably very clear, you know, through discussions with Lizzie and Ben. Sort of they've got that clarity, and they sort of feel that what they want to do with these assets. But a lot can happen within the lifetime of the company. So from my point of view, I'm trying to look at and consider and blend in as much flexibility in terms of an investment strategy to counter those potential liquidity issues down the track. Probably finally worth a mention, one's position of dry tax charges. Again, far from wishing to stray outside of my sort of area of expertise, but I have had experience of this, and it emphasises the reasons to liaise closely with tax advisor and the accountant, not least because I've seen a lot of interpretations of it. In some cases, it may be better to avoid using bonds, corporate bonds, for example, especially when they're held within a segregated fund. In the main, I think it's sort of, for me, it means that the tax compliance tends to be a little more complex than the actual tax liability itself. When we've run some models, liability is not great. So I guess it is a question down with the tax advisor or the accountant, and then balancing that aspect of investment diversification versus tax liability versus, you know, the cost of compliance. It could be that the decision at the end of the day is to hold, you know, the debt structure within a different type of structure. It could be, say, an offshore bond, which we know defers the income tax liability, and balance that with some equity risk within the family investment company. But again, you know, is that additional complexity when you actually balance that off against the tax liability that's created within that dry tax amount. Have I covered everything, or do you think there's anything else worth mentioning on that, Jane?
Yeah, no, I think you have covered everything there. I mean, all I would add there is just, again, a case study that, in fact, we've added an OIC into an OIC investment into the corporate. And that's really because, again, there's a philanthropic aim in this particular set of circumstances. Gains obviously are not chargeable within the OIC, so that's quite a win. But it also means that the income arising in the OIC is paid up to the FIC. to FIC level, the FIC doesn't have to pay tax on that. And then the directors / trustees can decide at what point there is any dividends paid from the holding company. So it's quite a neat way of just being able to sort of contain the tax and also just distribute it as is appropriate and is needed. The other thing that we will be doing is gifting shares in the OIC directly out from the FIC to the charities that are wanting to be supported. And that's you know, the increase in value on the OIC shares is a non-tax event in terms of corporation tax when giving it to charity, is my understanding. And also the full value of those shares that are gifted to charity are deductible against corporation tax. So again, that's just a colloquial example. Like Ben said, a particular nuanced set of examples. That doesn't mean that's right for every life interest trust. It's just in this particular set of circumstances with the quantums involved, this seems to work. The other thing we have an aspiration for is that it's philanthropic in sort of aim, but some of the philanthropic aims will be met through investing sort of startup companies with a particular sort of environmental focus. That may be less comfortable to do directly at trust level, according to the sort of trustees and tax advisors. So that, again, was deemed that actually having the family investment company within the trust, that might be a more comfortable place to be doing those sort of more esoteric private company investments.
I'm just reminded, actually, Jane talking about trusts and Steve, you talking about diversification, reminded of an example about trusts holding effectively a single investment, and the desire for trustees to diversify their investment, and how actually a family investment company can help with that. Because if you have a pre-existing family trust and a pre-existing family investment company, it might be possible to effectively enter into a reorganisation, which Lizzie will be happy to hear about, whereby the trust exchanges its interest in the trading company, let's say, for an interest in the family investment company. And that can be dealt with in a tax efficient way, but effectively, ultimately, the trust diversification aims can be solved quite quickly by looking at the family investment company as a means of doing that. But just, sorry, Steve, your comments about diversification and James about trust sort of linked the two in my head. But it is a useful example of a quick solve and keeping it within the family, so to speak.
No, that's great, Ben. Thank you. Okay, so I think my next point that I'd like to raise with you is about governance and compliance. So now I've had a few clients show at least a raised eyebrow, but sort of probably a little bit of concern about the level of compliance that's needed to run a family investment company. Have you got any particular comments as far as this is concerned? Perhaps Lizzie, start.
I think the thing to remember about a FIC is, although we talk about them as a special thing, they are at the end of the day a company. So that means that you're going to have to do confirmation statements, which used to be called annual returns. You're going to have to do accounts every year. But other than that, they are just a company. So anyone who is familiar with running a trading company ought really to be familiar with the requirements for running a family investment company. I think the bigger piece perhaps comes around setting it up in terms of the governance of it, with, I think we've talked about you really need to get the Articles of Association right, and they probably are going to be bespoke for every family investment company, because there will be different aims in terms of the share rights and in terms of who's allowed to own the shares, the permitted transfers and all of that. Probably there'll be a kind of shareholders agreement as well, a private document that sits behind the articles and talks about sort of certain reserved matters in terms of decision making, so steps that can't be taken without shareholder consent. It may be that not every company needs that, but that's something that we'd discuss. And then the other thing in terms of governance that we've seen is, I have seen some companies, trading companies and investment companies, want to have a sort of family charter, which is this sort of non-binding document of the principles and the sort of guidelines that apply to that company, and probably other investments, other trusts and all the rest of it. So there might be some work related to that, but really to a certain extent it's as complicated as the client makes it. So if they want a simple FIC, they can have a simple FIC.
Yeah, it's interesting you mentioned trust, Lizzie, as part of the family charter, because when we're often talking about family investment companies and as part of estate planning, they are sort of naturally compared to trusts, and there is a tendency to think that trusts might have less compliance to deal with, which might have been true in the past, but in recent years the administration of trusts has increased considerably. Money Laundering Directive 4 and Money Laundering Directive 5 mean that more trusts need to be registered with HMRC, and those registrations need to be kept up to date. Trustees need to maintain certain information about the trust, which the TRS stuff is useful for. But there'll also be like the annual returns on exits, and 10-year anniversaries to consider. Trustees also need to meet and record decisions and discussions with the trustees. So by comparison, family investment companies and trusts aren't a million miles away from each other in terms of their compliance issues. The other sort of tangent to this, and it goes back to what we were talking about in terms of funding the family investment company, and again, going back to the property investment side of it, the annual tax on envelope dwellings needs to be considered, which is obviously not something that needs to be considered in a trust context because it's not an envelope for that purposes, but it is possible that that's an additional consideration that needs to be looked at. As I say, I get asked about property investment portfolio incorporation, and it comes up as part of that, and it tends to get overlooked. There are reliefs, but those reliefs actually need to actively be claimed. You don't just get them. So there is that additional part of it as well.
Okay, and I know we keep labouring this, but from my point of view, particularly with the loans, in my experience, circumstances do change year on year, not least because of that liquidity requirement of loan repayment. So I'm at pains really to meet up with tax advisors, lawyers as well, to, I guess, plan 12 months, 24 months ahead, and try and cope with those anticipated changes, because within a short space of time, considerations can change from a person or a client or a sector saying, I don't want anything out of this, the loan's a loan and it will be there for quite some time yet, to 6 months later, circumstances completely changing, and that really made a profound difference to the underlying strategy at times.
And I would just endorse that, Stephen, just to say that any of our clients that are have a trust and or FIC, Lizzie and Ben are sort of underplaying their expertise here. If you want, there is a layer of cost to putting in another jam jar. It just is unavoidable. And that's where knowing what we're trying to achieve makes that the right decision to do. But I would urge anyone who is setting it up as a client, do not try and do that without an ongoing relationship with your lawyer or accountant to get that right. Because sometimes clients think there's when it's set up now, what do I need them for? But that's just the beginning of the journey. How to optimize it for your best interest, is about being sort of, hand in hand with that professional along the way. And certainly in the clients that we work with, that's our sort of mantra, and we urge it, even when clients sometimes are reticent, you don't know what you don't know is the truth. And, there's so many efficiencies that can be obtained by just knowing the nuts and bolts, which Lizzie is sort of making quite light of, but it's certainly really clearly there. I think for me as well that the recent review that HMRC had into family investment companies, and there was a big sort of waving of flags about the whole world's going to change with regard to this. Well, big flag, and then actually a damp squib. It was sort of like very quietly said, yeah, that's finished. Thanks very much. As far as I'm aware, there was virtually nothing, I don't think, Ben or Lizzie, that came out of it as a change. So I think, we should feel quite reassured in that,
Yeah, I've been boring enough to the minutes of the meeting that was on the HMRC website, and it's worth a read. There's only about sort of 40 pages of it, but probably 3 of it in relation to family investment companies, and it should give any advisor, I think, confidence that certainly from an HMRC perspective, that they were on the whole very comfortable that tax compliance was being adhered to, and they seemingly had a great respect for the fact of where FICs sat alongside trusts, given sort of the change in trust legislation. So it made FICs far more appealing as far as generational planning was concerned. So it's worth a read, if not only to give you confidence that things are probably not likely to change profoundly down the future, albeit no guarantees, of course. That's good. That's great. Thanks. So extracting funds is probably the next stage. We've talked about this in part, but clearly there will be instances where clients wish to take funds out either regular or one-off basis. And again, conscious there are enough tax people on the call. What are there any examples that panel could give in terms of what to look for and how this works actually in practice?
So in terms of the extracting funds point, I think the first point is to think about what family investment companies are or should be used for, which is long-term wealth generation and preservation. So when it comes to extracting funds, I really think at the outset, and we're having a conversation with people like Lizzie and Jane, is to be looking at how that's going to be, how the funds are going to be extracted, and obviously looking at a loan being used. When we spoke about how we would fund it, we also look at, is that going to be the main source of income? Is that actually going to be drawn on? As I said, it can be that the case that they are interest-free loans repayable on demand, which can be efficient for income tax purposes and inheritance tax purposes. Obviously, as I said, if it's going to be drawn on, it's going to be an asset that's creasing in their estate. Extracting property in specie can be very difficult. A difficult task, and I think that to a certain extent trust might hold an advantage there, but again it's talking about that at the outset, what's it going to be used for, and how likely it's going to be the case that funds are going to want to be coming out. Dividends taxed at the marginal rates, and if regular dividends are considered, it'll be important to consider whether taxing profits at corporation tax rates and then at dividend tax rates will actually make the client worse off. And that's really just a simple numbers exercise. But it comes down to, again, the structure of the family investment company at the beginning and the plan for that family investment company moving forward. On dividends, the alphabet structure Lizzie spoke about earlier can help to get income in the hands of family members. With lower marginal rates, either directly or via a life interest trust. That flexibility can be important. But again, as I said earlier, the settlements legislation is key here, making sure that we don't fall foul of that, because it can sort of undo some of the planning. And on a winding up, we need to be careful of the transactions and securities rules, because again, that can catch people unawares.
I think Ben's covered it all really on that. All I would say is that the particular example I had of a company or a trading company reorganisation that Lizzie would have loved. It was a dental business, in fact, so it had dental practices and property. It was a you know, as probably as Lizzie is very used to, and probably the rest of us would sort of hang our hearts and think, oh God, where do we go? You know, you get given this spreadsheet with all scrawly bits on, and that's the kind of current setup, and we need to sort it out. In this instance, it was two brothers where there'd been a lot of family funding into the company, but it needed a reorganization. And actually what they did was to put two effectively holding companies above the trading company. And that was so that each brother could have flow of dividends and profit going into their own individual holding company. But then coming back to Ben's point, you know, they could extract as they wanted, which for them was more efficient and meant that whilst there's a complete alignment on the business, how and when they spend are very different individuals. And that was really important because we were falling foul of being sort of trying to have a one size fits all when we only had, the plan was one corporate structure coming out, because one was very much about, I mean, literally polar opposites, you know, it all stays in the company, never comes out. One was, okay, well, I want to buy a bigger house and all of this. And that was in danger of actually undermining what was a very efficient trading business. So actually, it was a very simple sort of resolution with hopefully not too much cost on that. And I mean, the way we also extract value, if there is a trading element to the corporate, and it may not be all of that, is obviously through pension contributions made by the corporate on behalf of the individual, if we have that opportunity, and also, you know, paying for life cover through the corporate, which can be very efficient without P11D. But there needs to be a trading element to that for it to work. So, you know, it's not for everything, but it's, again, like Lizzie said, the basic structure is the same. It just depends what's inside it.
Sure, all valid points. Thank you. Okay, so final point is really to sort of put this in the context of wider estate planning. And I know we've talked about jam jars and you know, appropriateness of entities, but what observations would you make in terms of, you know, things that clients could or should be thinking about?
I think, and I think just touching on what Jane says about making light of the documents and stuff, I mean, the point about all of this is it's important, it's absolutely essential that you get it right from the off, because whilst things can be changed, they can't always be changed very easily. So it is important, you know, we talked about the documents and the setup of the FIC itself. It's really important to get the articles of association and the share rights down from the off, and that isn't just a case of deciding that that's what they are. They need to be properly documented. We need to have bespoke articles to cover that, and you know, to deal with that. Probably a shareholders agreement. And in terms of the wider estate planning, we need to fit all of that into divorce and death, which I talk about quite flippantly, but that's why I'm a corporate lawyer and not a family lawyer. But, you know, we need to think about how that works. On divorce, are we going to say, well, you've got to sell your shares back to mum, dad, family trust, whatever it is, at a reduced price, and what impact is that going to have on that person's, on that child, that siblings, sort of wider estate? And the same on death. You know, I talked about you know, with the example that we had, what happened to dad's voting rights, is all of that needs to fit into their wider estate planning and make sure that their will ties into all of this, that we're leaving control and everything else where it should be, because there's no point getting it right from the off if 10 years down the line it's not what they anticipated.
Yeah, from my perspective, with the private client lawyer coming out in me, wills and LPAs, they need to be made sure that you're effectively tying those into the articles and the shareholders agreement. I didn't mention it earlier when we were talking about structure, but what we'd like to see is to make sure that those things are thought of, and as Lizzie said, making sure they're thought of out the outset, because what we don't want is anyone to lose capacity and then find out that there's a problem. That's not you know, really what we're about in terms of setting up these family investment companies, because they really should be bespoke to you, and it's not as if these things are not unforeseeable. LPA should be considered, as I've said, and making sure that you're happy with the people appointed under the lasting power of attorney. In terms of the lasting power of attorney itself, it doesn't have to be just the one for everything. It is possible to draw dividing lines, but obviously not in the same document. And if trusts are going to be involved, then making sure that any letters of wishes are correctly drafted in terms of the purpose of the trust, although we don't really have purpose trusts, but in terms of why the trust has been established and it is being used, to give some guidance to the trustees, because later on, and generally speaking, and we might come on to it in terms of the HMRC's finding, but family investment companies are generally established by people 50 plus, according to HMRC. And in my experience, that, and as Steve said earlier, it's a certain point in your life. At some point, you're not going to be around to assist the trustees with what it is that your plans were. So ensuring the letter of wishes is correctly drafted and as detailed as you'd like it to be, but really as we'd like it to be as well, is key.
I think I'd only endorse and add on to that to say, just again, this I think is where everything has to come together like the Olympic rings, depending on what you're trying to achieve with the company. And just again, as by means of example, the dental practice business, how the articles of association have been drafted there is that on the death of one brother, the shareholding in the trading company can be bought by the other for £1. Now that all works because it keeps all the sort of expertise and the value with those that have it, which is appropriate. But both, they're actually reasonably young. We've got one who's married and one who's about to be, in terms of the brothers. And obviously what's important there is to make sure the spouses are looked after, because if you suddenly sold what was the generator of all the value for that family for £1 to the other brother, what's left? So what we've done there is to set up some pretty hefty life cover policies, which we've got as a reviewable position so that we can go back and make it relevant to the value that's in the company as it grows, but to make sure that the spouse who is suddenly left isn't left without resources. They wouldn't have the appropriate expertise nor desire to be involved in the business, nor would that be a positive. But it's very important they're looked after as the brothers want. So we've sort of fixed it for everybody. It sort of at the moment feels like it's a very stable position. What I would say is it's stable today. Where the business is even in 2 years' time will mean we constantly have to keep going back and looking at that, because that life cover policy could be out of touch very quickly in the sort of growth plans. I'm always going to bang on about pensions. So, just as part of general IHT planning alongside your wills, letter of wishes on pensions are vital. If your potential beneficiary isn't named on your expression of wish at the time of your death, they cannot benefit until those that have died. So, let's make it the fabulous succession tool that it now is. Whether it was intended that way or not, I don't know, but it is. So, yeah, that's my bet noir, and I'll finish with that.
Thanks, Jane. Thanks for everybody for the comments. I think that sort of brings us to an end of sort of the main topics of consideration that we wanted to discuss between us. In terms of questions, I don't think there's anything that's sort of come in aside from is there going to be a recording, which there is. I think that's been sort of sent out to everybody. And there will be a link for the recording sent out in due course. If I could just ask a couple of questions, I think we've got time. It's 12:15 now, so we don't need to sort of drag on. But I'm intrigued to know what your thoughts are as far as these concerned. We've touched on a couple, so I won't dwell on those. What happens, if and when the settler dies? More when, I guess, because I don't think I don't think being a settler makes you immortal. So when the settler dies, who ends up running the company? And who makes the decisions then? And can the shareholders appoint a director?
Does he look like you were answering this?
I do, but I couldn't find the unmute button. Technology failed me at the last moment. It depends on what we've said in the articles, really. I mean, the principle is going to be that whoever has the voting rights has the right to appoint a director. Where it becomes particularly messy is if shares are inherited, the estate don't actually receive the voting rights until they're registered as the shareholder. And if you've not got a director left to make that registration, they can't be registered. And we have seen a situation with a lot of older companies where we've actually ended up in court having to get the personal representatives registered as the holder of the voting rights to then be able to appoint a director. So what we tend to do is make sure that the articles cover it, so that if the settlor dies, whoever receives his voting rights, whoever receives his shares, can step in, be registered as the holder, exercise their right to appoint a director, and you can cover it off that way. But then it depends on who you want that to be, because it may be that, you know, going back to my example of 5 children, it may be that actually there's only one who you want to have the voting rights and the ability to appoint a director. It might be that you say, well, actually, I want the voting rights to go to external trustees. They can decide who the directors are going to be. So it's really a case of asking the questions at the beginning and making sure that it's documented, because if you stay silent on it, we can end up in a right old mess.
Ben, have you got any thoughts?
I was only going to say, we've had it, Lizzie and I have had it on another matter, not family investment company based, because it's not too different from a trading scenario where you have got a family trading company. And in fact, actually, some family investment companies are used as trading companies, as a sort of training company for perhaps a larger, I've seen that, I've done that. But it is pointless having the family investment company articles and shares agreement all set up in the right way if you then go and leave your will untouched. And all too often in these scenarios, the most appropriate will is a discretionary trust will, because it gives us more flexibility, both short-term and long-term, in terms of the management of that interest that the estate will be receiving. And it might allow us to do some tax planning on first or second death, depending on whatever it is.
Thanks, Ben. Final question, if possible, and you did open yourself up for it towards the end, which was, can you sort of explain any views or experience of incorporating a partnership into a FIC?
Yeah, so as I sort of said, it depends what kind of partnership it is. So the most common one I get asked about is property investment partnerships. The reality is I have seen arguments against what I'm about to say, but I don't quite follow it. So what we usually see is that, let's say mum and dad have a property portfolio, and there are usually question marks over that, whether that is a partnership or is it just co-ownership. And there is a definition of partnership under the 1890 Act. And it does really require more than just 2 people receiving income. Questions that also go out to, is it filing a return? Is there a partnership agreement, i.e. is the partnership filing a return? But when it comes to transfer, let's say, the assets of that partnership to the company, there will be capital gains tax charges on that. It is a disposal. There are reliefs available for that. But from an SDLT perspective, where, as I say, it's more often the case that I get asked about it, effectively, if you transfer assets into a partnership and within 3 years a certain event happens, which can be incorporation, the SDLT benefits that come from the partnership regime can essentially be withdrawn, and you end up triggering an SDLT event on what could be quite a considerable amount of value, and bearing in mind it's likely to be a connected party, the company, so it'll be at market value. It could be quite a considerable tax charge, but that's not to say that it's not possible. It's just that there are hoops to jump through, both for a trading company or a property investment, trading partnership or a property investment partnership. It is possible, but it requires planning and advice, and of course, part of that, corporation advice and tax advice. And of course, as I said, is it even a good idea? It is putting it in the company just going to cause problems from an income tax perspective? Are you going to end up trading, one problem for another? If it's going to be accumulated, then companies, generally speaking, would be better than a partnership where the tax is transparent. But yeah, so the most common one I get asked about is property partnerships. And there are problems with doing that, but they aren't insurmountable.
Thanks, Ben, and thanks, Jane, for pointing out that we have got a question in from Tom. So thank you, Tom. We've got a few minutes left, so we'll see who picks this up, and it's a long question, so bear with me. Appreciating that it's better to set up the share rights and structure from the outset, if the client has a FIC that is the only director and shareholder, but then wants to introduce, for example, daughters as shareholders, but with perhaps rights to capital growth but not income, will this trigger a tax event? For example, if, say, there is £750,000 of cash held in the company and the father wants to buy a property and rent it to the daughters, and that they have the benefit to capital growth, but he receives the rental income, is it better to issue shares now with no rights to capital and then change it later so that the shares have minimal value?
Shall I take in the first instance? The starting point is that if it's going to depend on what the company's worth, whether the company really is worth 750,000 or whether it's got a loan outstanding, which means that it's probably worth nothing. But if we assume that the company is worth something, Dad has all of the shares in that company, he therefore has all of that value. If shares are to go to the daughters that have some right to capital, whether it happens by an issue of shares or by a change of share rights later on, he is going to be disposing of some value and giving it to his daughters, which, you'd need to have a look at the tax implications of that and of that gift effectively. If the company's worth nothing, this is why we always say get the structure right before the company is worth anything, because when the company's worth nothing, you've got nothing to be given away. So if you end up setting up a FIC that all of the value does sit with mum and dad, for example, which we have seen, but actually that value is only £5,000 or something because there's loans outstanding and it's not really worth very much, it doesn't matter overly much at that point if you start making gifts of those shares and fiddling with the share rights at that point. But if there's a lot more value there, yes, on the face of it, there's going to be some kind of gift.
Thanks, Lizzie. Ben, you got anything to add?
I think, sorry, that Lizzie is part of that as well. A question about attributing the growth. So father wanting to buy a property and rent it to the daughters, and the benefit of capital growth, but he receives rental income. Is there a particular issue then in attributing income from specific assets to specific shareholders?
No, we can do that. And again, and that's probably not going to be, there's no gift there, is there? Because there's no transfer of value. And again, if it's only the growth that you're attributing to a certain shareholder, then probably there's no transfer of value at that point, because you're keeping the first 750,000, and that's the same as keeping your loan account. So it is going to depend on precisely what it is that he wants to give to the daughters. But if he's giving some value away, that's where we've got a problem. If he's giving the future potential, much less of an issue.
Yeah, I think my biggest concern will be about the getting the shares to the daughters in the first place and the tax events on that. which need to be looked at closely. But I think, like Lizzie said, if it's got £750,000 worth of cash, but actually there's also a loan of an equivalent amount, then it's not necessarily going to be as big an issue. I don't think that necessarily completely answers the question for the person that's asked it. It's somewhat of a lawyer's answer, as we've been doing throughout, which is it depends. But to the person that's asked it, if you want to discuss it after, we can do.
Great, thank you. Thanks, Ben. I think that's probably a good time to draw things to a close. So I hope that this conversation has provided you with some useful insights into our knowledge and working experience of dealing with family investment companies. The intention is definitely to provide a link to this recording of the last hour or so. So if you would like to track that down and fancy a revisit at any particular point, then please do so. If there are any questions that have come through since answering the last one, then we'll clearly follow up those with you in due course. It just sort of leaves me really to thank Lizzie, Jane, Ben for your insights during the course of this discussion. And with that, I will close the call and wish you all a pleasant rest of the day.
Thanks very much. Thank you.